Hi, I'm David Singer. I'm an attorney here in Florida, and I've assembled a panel here today to discuss maybe one of the most important cases of the 21st century. The century is young, but clearly the Trayvon Martin, George Zimmerman case has captured the minds of the public. As you go around the community, everybody is talking about it. Over the weekend, we have a verdict in the case, but there's a lot of interesting things to still discuss and interesting things that need to be reviewed. There are a few things we know about the case for sure. About 18 months ago, teenager Trayvon Martin went to a convenience store, bought a soda, or actually an iced tea, Skittles, was wearing a hoodie on a rainy night, and was coming back through a complex to his father's home. At some point in time, George Zimmerman sees Trayvon Martin and begins to get suspicious of him. He calls the police department and says basically, "I'm suspicious of someone that I see on the premises." And the dispatcher of the police department says, "Don't follow him." Well, George Zimmerman doesn't obey those directions, it seems like, and he does start to follow Trayvon Martin. And Trayvon Martin also is on the phone more or less at the same time with a female friend, and he says he's nervous and he's in fear of the guy that seems to be following him. So when that conversation, Trayvon Martin's cell phone conversation, ends, we don't really know what happened for the next 3.5, 4 minutes or so. The story gets picked up again when there's a 911 call by a neighbor that hears screaming. And at the end of that screaming, she hears a single gunshot. Now, the question remains, and maybe the crux of the whole prosecution of George Zimmerman, is what went down in those 4 minutes. That seems to be critical of this case. Now, Alan Dershowitz, the Harvard Law professor, who I often agree with and often don't agree with, was quoted as saying that this case never should have been brought in the first place. So I'd like to pose that question to a longtime murder prosecutor here in Broward County, Chuck Morton. And Chuck, what do you say to that sentiment that maybe this case shouldn't have been brought at all?
You know, Alan, I've given that some thought, and I've come to the conclusion that perhaps it was a very beneficial thing that this case did go to trial. And the reason why is because for a police agency or even a prosecutor's office to unilaterally make the decision not to prosecute in a case that was had so many different controversial issues and circumstances that reasonable minds could differ. Reasonable minds could differ on this case. And for an agency to unilaterally make that decision would have put this case in a cloud in which people would never stop questioning what happened in those 4 minutes. So by it being aired out in a court of law, that's exactly where it should have been, and it was probably the best thing for this country.
David, if I can comment on that, from a legal viewpoint, I might feel that the case should not have been brought because it seems like it was fairly clear that there would be a not guilty verdict, or there should have been a not guilty verdict under the facts of this case. Although surprisingly, if Trayvon Martin had actually killed George Zimmerman, I would have also said that probably a not guilty verdict should also have occurred because he could have argued reasonable fear. People forget the high burden in a criminal case. But from a community and societal viewpoint, I tend to agree. I think that because we had all this testimony, because the public actually saw and had the opportunity to hear why Mr. Zimmerman was found not guilty, that probably did help, I think, the community.
I think it was fortuitous that happened.
Now, Pedro de Jules, it was kind of an unusual circumstance. The police department didn't think, the Sanford Police Department didn't think that there should be a prosecution here. The state attorney's office in that county where Sanford is didn't think that there should be a prosecution. But several weeks later, the governor intervened and turned it over to another state attorney's office, the one in Jacksonville. Did the governor make the right decision?
Well, before we get to that point, tell me if I'm wrong about this, but I think the state attorney's office in that particular county, Sanford, they had not yet made a decision. I think they were about to take it to a grand jury, if my memory serves me right. They hadn't yet made the decision, but I think it was clear that they were probably leaning toward the police department. I think the governor may have jumped the gun. I think if you look at the timing of some of these decisions early on, there's an argument to be made that, and this is speaking from the defense point of view at this point, and I'll get to I can answer later as a former judge, but from a defense point of view, I think the governor may have jumped the gun a little early. I think that they should have been a request from the state attorney, and I don't know if there was a request. I don't think there was at that point, but or at the very least, let that state attorney take that case that happened in his county to a grand jury and let the grand jury speak. The governor decides, however, to have this particular prosecutor come in, and I think, obviously, whether or not they should have gone to, the jury has spoken already. It's obviously they probably should not have filed an indictment against Mr. Zimmerman. However, again, as Mr. Morton has stated earlier, some minds could have differed in that respect, and I think there's some argument that charges could have been brought forward. I just think it just looks kind of strange the way it got to where it got to with his new prosecutor, and obviously the local police department up there, they investigated it, and in fact their investigation seems to be relatively. There was a couple of little issues I had with them, but I think their investigation was pretty detailed. And there was no indication that they were trying to hide, that police department was trying to hide anything or make up any stories or do anything that was a problem. And I think the state attorney up there should have been given an opportunity at least to present it to a grand jury. But I just think politically, it looks like this was a political prosecution, or at least they would file these charges because of political pressures.
Can I give you a little insight on how cases are actually assigned executively? I dealt with this for a number of years. In the last 7 years of my career, 37 years at the state attorney's office, I was chief assistant state attorney and requesting executive assignments where there appeared to be conflicts on behalf of our office. And the way this works, particularly in a homicide case, there are a couple of ways you can make that charge. You can do it by direct information. That means that we could file the charge, that is the state attorney's office can, or you can present it to a grand jury. It could have gone through what's called a court inquest by statute. But in order for something to generally, the pattern for executive assignments is that the state attorney's office itself in that jurisdiction makes a determination that there appears to be some kind of conflict, or there may be an appearance of impropriety. And they will make a written request to the governor's office to assign an outside prosecutor. My understanding that it had not quite gotten to that point yet, and I'm not sure if the former state attorney who was handling this case at the time, Norman Wolfinger, had actually made the request. He had considered taking it to the grand jury, and quite frankly, you're right. It was political pressures that caused the governor to come in, and then perhaps on his own, perhaps too quickly, to assign this case to another prosecutor. Within this, and I would pose this question to former Sheriff Lamberti, who's sitting next to me, and he's been in law enforcement a long time. You see, prosecutors and police officers, oftentimes people think that we go hand in hand and we agree 100% with one another, but the sheriff or the investigating agency is the chief law enforcement officer in that jurisdiction as far as investigating the crime. The prosecutor is the chief law enforcement officer as far as the court, the charging of the crime. And sometimes we do not agree, say, for example, as to whether or not someone should be arrested
I know
or
that
detained.
That's the case because I've seen Law and Order on TV.
Okay. Arrested or detained. And in this particular case, he was not arrested nor detained, And that created a big controversy as well among the people in the community. And I'm going to speak from my experience and your experience. I did not disagree with the fact that he was not arrested or detained that particular night. And from a law enforcement point of view, at least a sheriff's point of view, what do you think?
Well, and I've been asked numerous times in the past 18 months exactly that. If this would have occurred in Broward County, what would have happened? Would he have been arrested? And I could tell you the way the case went down, we would have been on the phone with the on-duty state attorney. We would have been discussing it.
Which I've done many times.
And I can't say we would have made an arrest or not made an arrest. We might have, but in something like that, you're in consultation with the state attorney's office. So in a case like that, you are hand in glove because you can make an arrest, but if you don't have the support of the prosecutors to go forward with it, you're basically wasting your time. So you want to make sure that you are on the same page. And again, I've been asked it dozens of times, would you have made an arrest? And it's a hard question to answer. You don't know. You can't say definitively, until you're in that position.
If I could, after you, I wanted to comment on that.
No, I think that there was enough to arrest him at that particular time. When you listen to the 911 tapes, the comments that were made by George Zimmerman, these punks get away with it all the time. And I think what's so salient here is the fact that he was instructed, not required to, but he was instructed to not get out of the car. And I heard his good friend Frank say that, well, he wasn't required to stay in the car because they said that. But when you put all of that together, I think a prudent decision would have been for him to have been arrested. Because normally when you have self-defense is an affirmative defense, which means that I committed the act, but there is some legal justification. That should have been enough for a grand jury to at least make that determination.
And that's the issue that I was just about to bring up. There is a difference between the self-defense, which was used at trial, and the fact that they thought that he would claim stand your ground, which I was in the Senate when we passed that. I think it's a horrible law, but there is a provision in the stand your ground law that says that if you are arrested and you successfully plead stand your ground at a hearing, that the law enforcement agency that does the arresting is required to pay not only your costs but your fees. This is virtually unheard of in any area of criminal law except stand your ground.
And I do want to talk about that later on.
That was a factor in their not arresting him, because they did not want to run the risk of an adverse hearing in stand your ground.
Well, I do want to bring something up, and I'm again speaking as a defense attorney, and as a defense attorney, I disagree with you about the 911 tape. As a prosecutor, I would think differently, obviously, but as a defense attorney, I think if you listen to that tape, and I have my defense attorney listening on it. When he said that, I don't think he was very specific as that this punk is going to give it, these punks, yeah. But again, I don't think that rose to the level that that there should have been any real concern that this was any ill will or spite or hate. I think he's on the phone, he's not yelling it, he's not screaming it. More important, that situation where the 911 operator is saying don't follow him, that's not a police officer. That's a 911. That's a civilian. They're saying don't follow him. And the next sentence, if you hear the tape, if I recall correctly, by the way, don't follow him, but what's he wearing? By the way, where is he now? And so he's asking him questions about the location of Mr. Martin. And again, my condolences go out to the family. There's no doubt this was a tragic situation. This was a perfect storm of unfortunate incidents that occurred because, again, Mr. Gelb, I think you're absolutely right. I think if the shoe was on the other foot, legally, Mr. Martin would probably be able to use the same law of self-defense.
No guarantee he would have gotten off also, but
there is no guarantee, and I don't think he would have in this state.
I agree that there's a problem, but legally he should have gotten off as well because of the high burden of self-proving.
But on the response as to the fact that the person on the 911 call was not a police officer, typically when you speak to someone at the police department, you consider them as an agent of the police department, of that police department. So most people that call in, I don't think they know whether or not the person on the call is a police officer or a non-police officer.
Johnny,
we know that they're not.
Johnny, in response to what your statement that he should have been arrested, First of all, let me just say, even had it been a law enforcement officer on the telephone, legally, an instruction on the telephone would not have been legally binding. In other words, it wouldn't have been unlawful for Zimmerman to continue to pursue.
And I can see
because,
that.
because
I said that.
disobeying.
I want to get back to law enforcement with Sheriff Lamberti. I've seen a lot of trials in my day, but we know from Law and Order and just from general knowledge that there is sort of a give and take among the state attorney's office and the police department. But in this case, there seemed to be unbelievable cooperation between the Sanford police and the defense. And I'm wondering, am I right that is a very unusual circumstance that happened in this case?
Well, to dovetail on what Mr. McRae was saying, and I was waiting to respond to him, if I'm a detective on the case of a fatal shooting, I can tell you, most detectives I know, they're going to want to make an arrest. They are going to want to make an arrest. If I'm the lead homicide investigator, I'm going to want to arrest the perpetrator. So I think the feeling of the detective who shows up on that, he wants to make an arrest, but he also wants to get the case prosecuted. So there is a balance. So my initial thought when the case happened, my first answer to everybody was, "Oh, yeah, absolutely. Broward Sheriff's Office, we would have made an arrest in that case." But then as you step back and you start to hear more of the facts come out, again, you also want to make sure that you got a prosecutor willing to take it. As far as cooperating with the defense, it was for the law enforcement side of this, for the prosecutors after about a month to come in and after the investigation has been going on, because usually, you have your prosecutor, you're hand in hand from the very beginning. To go 4 months and then have to start all over again, I think that created a problem, and it might have been, that what created that thought. The defense was there from the beginning.
Just to refresh our viewers' memories, when asked on the stand, the investigating officer with the Stanford Police was asked by Mark O'Meara, the defense attorney, did you believe George Zimmerman? Is what he told you consistent with the truth?
And that was improper.
That was an improper
The
question?
case law in Florida is clear.
Yes.
One witness cannot bolster the credibility of another witness. By
Common
asking, do
credibility.
you believe that he or she was
As a
telling
matter
the
of fact, the
truth?
prosecutor was asleep on that question and didn't object, and then came back the next day, raised the objection, and the judge
the bell was
sustained
rung
it
at
and
that
told the
time.
jury to disregard it. But the bell, you rung
Yeah.
the bell. So how do you
Good luck.
unring the bell?
Right.
Now, and to say this, I've received many calls over the years that I've spent 20 years in the homicide division. 15 of those years I was in charge of the homicide division here. I've received many calls at night from police detectives in fatal shootings, particularly when you have one-on-one shootings where there is no witness and the person who did the shooting is claiming self-defense. Many times I have, on those occasions, have said, wait, do not arrest. Let's continue with the investigation and review, because we must be able to prove beyond a reasonable doubt that the claim of self-defense is not true. We have to prove that it was not self-defense beyond a reasonable doubt. And so the best thing to do is to continue with the investigation until we don't want to make a premature
speedy
arrest.
doesn't start
You don't want
running.
to start a
Right.
speedy trial issue. And many times detectives and I have agreed upon that. And perhaps in this particular case, to be honest with you, having done this many times and knowing the facts and given the controversial facts that could be interpreted in a couple of different ways, with a 4-minute gap, we don't know what happened, what that tape meant, I probably would have advised the detective not to make the arrest immediately.
I
Here,
think
can
it's
say one other
important for
thing?
you just to elaborate, because I don't know how many of the viewers know about the speedy trial rule, so if you could elaborate on
Yes, if an arrest is made within 175 days, if the case is not charged or brought to trial, then it can be dismissed with prejudice and no means of prosecuting again. And so you're better off waiting, doing a thorough investigation, and making sure that you can go forward with this charge before you trigger the speedy trial rule.
But, Chuck, one of the things that I want to be clear on, had a decision been made by Sanford to not go forward, hadn't the investigation been closed?
No, not necessarily.
Well, you said
because see,
Not to arrest.
not to arrest, but because you're not arresting doesn't mean you're not
no, I
continuing to
understand, but I'm
investigate.
asking, had the investigation into this shooting, hadn't it, they basically finalized.
Okay, let me say, and this is the only thing I've spoken publicly about this on a number of occasions. I think you and I have been on a couple of panels in different areas. I would not fault the sheriff, nor the state attorney if the state attorney advised do not make that arrest. I don't think, based on the facts that I know, that I would have advised to make an arrest immediately that night. What I think went wrong in this particular case, this is one of the reasons I have an opposition to the stand your ground law. I don't have an opposition to the general statement that a person can stand their ground and use force if they're in a lawful place. That has always been the law, even in common law. The response to the stand your ground law was a response to a judicially created rule that you were on a duty to retreat when you were in public. That was not required by the original self-defense law, and it was an overreaction. What I do not like about this, what I think happened here, was that when the sheriff, because of the confusion that it raises about who's immune from prosecution, who really makes that decision as to who's immune? Because the prosecution is defined as an arrest, it's defined as a detention, it's defined as a charge, saying you're immune from it, and you may have to pay cost. So a deputy shouldn't be making immunity decisions. That's usually for the court. Prosecutor can make some limited immunity decisions, but it should be for the court. And this created such confusion that what happened was that even though it was a typical self-defense case, there was with some racial undertones, but it was a typical self-defense case. I've seen many of those, one-on-one. They're difficult to prosecute. They're difficult to convict. The conviction rate for those kinds of crimes, when the only witness to the crime is the survivor who's claiming self-defense, the conviction rate is very low.
Well, I said from the very beginning.
Okay, but let me say this. But what happened was, not making the arrest was the correct decision. It was a public relations error, I think, that occurred when the announcement was made by the sheriff that we're not arresting because of stand your ground. That should not have been done. Because if you notice, even in this case, stand your ground was not the issue and was never raised pre-trial. And so that should have never been announced, and that created the problem.
Pedro DeJoles to put your prosecutor's hat on for a moment, and
one of the hats I've worn.
We're dealing with a 4-minute gap of a lot of information. Mark O'Meara, in his closing argument, actually took out a stopwatch and had that jury listen to what it felt like, how long 4 minutes are. How would a prosecutor go about, in this case, proving what went on in those important seconds where there either was a crime or wasn't a crime?
Sometimes you can't. It's called raising inferences. You can maybe raise inference, but then you're raising inference upon inference upon inference. It gets to be a problem. And let me tell you something. In terms of, at the beginning of this case, the prosecutor may actually, in their minds, had a good faith basis to go forward, because I've been there, Mr. McCrae's been there, Mr. Morton's been there. When you're in trial, your case is almost like a living, breathing organism. You just don't know where it's going to take you. And your witnesses in the beginning, some of these witnesses that the press claimed to be horrible and they really destroyed the state's case, some of those witnesses may have testified much differently pre-trial than they did on the stand. Some of those witnesses may not have come off that exact same way. And as a prosecutor, sometimes as a defense attorney, you can't control that. You, as a prosecutor, can just put on your witnesses, tell them to tell the truth, and you can pre-trial them as much as you want. But I can tell you from past experience, they'll take the stand, and sometimes it's like you've never talked to them.
David and I see the same thing in civil trials as well.
Yeah.
David, I recently tried a case in Central Florida, not too far from Sanford. I won't call this city. It's a different world. It was a different world in that particular county, in that particular city. They were not accustomed to seeing lawyers of African descent. I was looked at differently than the prosecution, than other defense lawyers who I saw in and out of the courthouse. The young lady, Gentile, I think her name is. Some folks said she wasn't a credible or believable witness. I disagree with that. And that's why one of the biggest problems in the judicial system right now is jury selection. And I know we cannot guarantee that there will be persons of different cultural backgrounds on a jury. We need to engage in some dialogue to see if we can improve this system. Because when you have 5 white women and a Hispanic woman who perhaps are not accustomed to dealing with certain persons from different cultural or socioeconomic backgrounds, certain individuals who may talk a certain way, that person may not be received as credible. And that's why I think it's so important for us to try to come up with a better system, a better way. And we have the best system. I don't take that away from this great country. But we need to engage in some dialogue to see what can we do to try to ensure a better degree of diversity on these juries.
Let's throw that very good question, Johnny, to our representative from the legislature. What can the legislature do? What have we learned from this case to make the criminal justice system a little better in Florida?
Look, let me say a couple of items. First of all, it's important to understand that the jury pool wasn't chosen from Sanford. The jury pools are chosen on a county-wide level, not on the city-wide level, number one. Number two, as we know, sometimes, for example, you have to move a jury trial. I authored legislation successfully that says if you're going to move a jury from one county to another, or a trial from one county to another, you have to consider the demographics of the county that you're moving it to, and it has to be moved to a county that has as similar as possible demographics to the county that you're moving it from. That is the law in Florida. I know because I passed it. I can tell you that Orange County, if you're going to move something out of Broward County, it's probably going to end up in Orange because they're the county in the state with the most similar demographics to Broward. But I think that it is important, and these are constitutional law issues, and I don't do criminal law, so I can't really comment on that. But I can tell you as a political leader, it is very important for people in whatever community, whether Hispanic, African American, GLBT, whatever community you're from, it's very important for people in that community to feel that the jury pool is representative of them. And if that doesn't happen, that's when people feel that there is racial injustice. I think that this verdict would have been the same if there had been 1 or 2 African Americans on the jury. But if that had occurred, I think you would have heard far less recriminations afterwards.
Let me just say I agree with that totally. I've just finished homicide cases, prosecuting them just a short while ago involving African American victims with African Americans on the jury. But it was a very, very difficult case, circumstantial case, and even with that, the jury did not convict. And so color doesn't necessarily guarantee convictions, by the way. And let me say this from a legal point of view and a perception point of view. Constitutionally, legally, in criminal law, no person who you hear the term all the time, trial by my peers. Constitutionally, trial by my peers does not mean someone who looks like me, someone who's exactly like me, someone who's from my same culture, from my same ethnic background, from my same race. Constitutionally, all it means is that you are entitled to be tried by the people within the county or the community where you live, first of all, or where the crime occurred. And what the Constitution guarantees is that certain protected classes of people, races, ethnic background, sex, so forth, cannot be systematically excluded from the jury. Not that you're entitled to have them on the jury, you cannot exclude them from the jury. In the landmark case on this, and I mentioned the other night, and perhaps the audience would like to know, there's a case that was decided by Justice Thurgood Marshall years and years ago, where a white man was indicted by an all-white jury in the South, I believe it was Georgia, and convicted by an all-white jury on a criminal case. The attorneys were smart enough to realize that the African Americans or blacks were excluded from participating in the panel because of property requirements, which were unconstitutional at that time. He appealed it all the way to the Supreme Court. And Justice Marshall said that man's constitutional rights were violated because blacks were excluded from the jury. And that's why many times people don't understand that. I don't understand why people are making this motion only when whites are on the
Right.
jury when a white can take advantage of the same rule.
Well, Chuck, I've tried cases with all white juries and I've been successful.
Mhm.
I've had cases with more than one person of African descent on it, and I've lost. Recent case, the Matthew Bent case. There was some other issues in that case.
I understand.
Very interesting case. But I'm not saying that simply because a person of color is going to be seated on a jury, I'm going to get my client off. What I'm saying is, as you said, perception.
It's perception. That's
perception.
what it is.
It's important that the community feel
Right.
that their interests
And I agree
were
with you totally on that.
If,
Perception.
as was said the other night when you and I were on the panel together, I think Howard Finkelstein
Yes.
said, if there had been one or two blacks on that jury, we probably would not have been in that town hall meeting the other night
That's true.
because we would have had more faith in the system.
And
if they had come,
would have had the same result.
absolutely, but you wouldn't have had this much tension.
We agree.
I'd like to get into something that I find very interesting, sort of Monday morning quarterbacking, to look and see how each side, defense and prosecution, handled their case. And I want to start with something that I think is universally agreed by prosecutors and defense attorneys and viewers of the trial alike, that the prosecution's ME, medical examiner, I think his name was Bao, B-A-O, was absolutely horrible. Have you ever seen a medical examiner that's bungling like that in all your years?
And what you said earlier about the defense, I mean, the defense, their expert witness regarding the gunshot came across much more believable. And he is an expert. I mean, he's written the book on gunshot wounds. But yeah, you depend on your medical examiner, to get in that crucial evidence. I mean, they have to be a solid witness. Like Judge Joe said, you can't say when they're going to get up there, but somebody who's a professional needs to do a better job than that.
And I think that kind of adds to the hysteria. I think that when you have persons of color who are already suspicious of the judicial system, you have a key witness for the prosecution who gets on the stand and who takes the positions that he took, that raises some further doubt.
If I can comment, I think that may be one of the legitimate concerns, but not for the reason people think. The legitimate concern is the medical examiner did not have any recollection, Dr. Bao, any recollection of what occurred. And I think that's because at the time that the autopsy occurred, this was not high profile. He saw, yes, it's another young African-American male who's died from a gunshot wound, and did not pay necessarily the same attention that he would have if the victim were a middle-aged white individual, where he might have remembered it better. So I don't think there was anything that he was throwing it or anything at trial. I just think he didn't remember the autopsy because it just didn't stand out in his mind. It wasn't significant to him, and that may have been because of the ethnicity of the victim.
And if some of the issues were not apparent at that time,